What was your impression? How do you think the case went on both your sides? Let's just get.
Well, I'll defer to Michelle, who went first and who represents the appellant.
Okay, Michelle McDonald representing the appellant Joseph D'Costa. I don't think that the judges understand fundamental rights. I believe that these judges believe that the Constitution gives us rights and it's not there to uphold our rights. There, I said it.
I think that the courts were not so concerned about the fundamental rights because they felt that the statute protected those rights. From our perspective, the respondent's perspective, and by the way, I'm Shannon Fitzpatrick, and I represent Carol D'Costa, who is the respondent in this matter. The questions to me were more focused on child support and whether or not there should have been an initial child support order in this case, and I tried to explain that the practicality is that it's very difficult to get an early motion on child support, but in any case it doesn't matter because the court has ample authority to award child support for the first time at the end of the case, going back to the beginning of the case, and that that this derives from a parent's right to support his or her children from birth. And in this case, although Mr. D'Costa did support the children up until the case was started, up until he was served with the pleadings, he stopped supporting the kids as soon as he was served with the papers. And therefore, for the 3 years of litigation, he paid no support, and that is not fair to the children.
I beg to differ. First of all, when you marry somebody and have kids, there's a duty to support. When you separate, you're typically still supporting in the same manner that you did. These children were supported with a home, all the basic necessities of life, health care, education. Love and companionship is what was missing. Love and companionship with their father, which was what was taken away by Ms. D'Costa and her attorney here, Shannon Fitzpatrick.
Well, he didn't support the kids after he was served with the pleadings.
Yes, he did. He didn't pay the wife any money, but he still owned half of the home, and he was still supporting himself, and the kids were still supported. So monetizing the relationship at that stage is not fair. It's actually a deprivation of the money that he could use to do whatever he wants with, including supporting the children. So he was paying to have supervised visits and everything else. So we've monetized support. Support has now become, oh, I didn't get any money this month. When support in its heart of hearts during a marriage is just providing a child with a home, food, all the necessities of life, education, which now is public, and health care. The love and companionship is what is lost when people want to litigate parenting time. The children, I have not had, okay, let me ask you this. Have you had even one client walk into your office wanting to have a divorce where their children were not supported with a home, okay, whether it's living at the mother-in-law's, food, clothing, all the necessities of life, education? Who provided it? Right.
In this case, my client provided all of that. Mr. D'Costa paid not one dime of financial support to these children.
But you didn't answer me when Ms. D'Costa
Well,
came to your office.
Well,
Okay.
let me ask some questions.
Yeah.
So it seemed the court tried to focus on the issue of a fit parent was a factor.
Yes.
And of course,
Yes.
most of parental rights do revolve around where the parents fit. So, I mean, you have this unalienable right as a parent, custody, until those unalienable rights are taken away somehow. And so what I heard Ms. McDonald saying is that those fundamental rights weren't properly protected by the statutes. In a sense, almost what I'm hearing is it should have been a criminal case, in a sense,
Or a child.
or that level of scrutiny over deciding whether one parent should lose time with their kids?
Again, the courts can only enter the realm of family and determine these things, is my argument, if there's a compelling state interest. So in this case, there wasn't a compelling state interest to keep a father away from his 8-year-old. There was no crime that was committed. There was no neglect. There was no abuse. In fact, in the court, I started to look at the statute for child protection, and I started to ask my client questions, and I started to ask the custody evaluator questions, and the judge stopped me and said, this isn't a child protection matter, so we're not even going there. In the end of the day, in a footnote, he says, well, you know, if the definition of unfitness is there's some future concern that he may emotionally harm the children or physically harm the children, and remember, this was yelling behaviors. This was not physical or emotional abuse that was going to be harmful to the children. It was all perspective.
Yeah, and that's basically your case. You're saying that there was the opportunity to say, had the allegations brought against Mr. D'Costa, and he had a chance to rebut them. And
Well, what I'm saying is that I agree that there's a fundamental right that cannot be invaded by the state unless there's reason to. And in this case, there was ample reason to, because there were pages and pages and pages of findings of the atrocious behavior, conduct that this father inflicted on the children. There were pages of instances of demeaning behavior, of angry emotion, and the court did find that the children were emotionally harmed and that that was akin to abuse. And so my point is that these fundamental rights, you lose them when you're an unfit parent. And Mr. D'Costa lost the fundamental right when he was found to be unfit. And therefore, you do not have to go through this constitutional analysis of whether or not the statute was narrowly tailored to the compelling state interest. Bottom line is the compelling state interest in this case is not the parental rights, it's the children's rights.
but do parents have rights?
Yes, parents have rights, even unfit parents, and I said that he had the procedural due process right to a fair trial.
So when do children's rights supersede a parent's right?
From the beginning. The
So
state is more concerned about, should be more concerned about the children's welfare than about the parents.
So I'm hearing something different than what I think you're saying. So what I heard you say is that a child has authority over their parent.
No, not that the child has authority over the parent, and I'm sorry if I'm confusing you. What I'm saying is that the state, constitutional analysis comes down to whether or not the state has a compelling interest. The compelling interest in this case is to protect the general welfare of the children, and that is paramount.
The safety, so if a parent is choking a child, beating a child, that's a criminal issue, right? Well,
yes.
where is emotional safety protected in the Constitution?
Well, we're talking about harm. General welfare means more than just physical welfare. General welfare means you emotionally take care of these children too.
Okay.